This is the third panel of the presentation. Congratulations to those who've stuck around for the entire thing. The first panel, if you notice, focused on the first 7 articles of the Constitution. We had the powers of Congress and powers of the executive. This panel focused on the Bill of Rights, and we'll be focusing on 3 professors, and it's a special privilege for me. So I mentioned earlier that I took Common Law 1 in this room back in 2006 or 7 with Ron Rotunda, and that's where I sort of developed my love for the Constitution. Common Law 2 I had with David Bernstein, which was the room above this one on the second floor. I can't remember what number it is, 2 something. And I learned everything. I remember saying, my professor told me that Locke knew about social Darwinism. He's like, no! And that was before his book was published. And then I took with Professor Lund a class called the Founders Constitution. Do you still offer that? That's not offered. No? That was probably the most significant class I took in law school. We read the entire Federalist Papers. We read Madison's records of the Constitution. We read from the Anti-Federalist. We read all the primary sources. And just to give you a sense, I had that class in 2008. That was before Heller was decided. Heller was decided, I think, the summer between my second and third year of law school. So that was just a very amazing time to be an originalist, that you could have ideas from Nelson and others that sort of make the way to the Supreme Court. So I'm very grateful. The third speaker, who's in the ether, Rob, you there? Rob Leiter. Anyway, Rob Leiter was a professor here at Mason.
I'm here.
Okay.
Sorry, I'm on mute.
No, that's cool. That's cool. Rob Leiter was a professor here at Scalia Law for several years. He is now in the administration. He's the general counsel at the Alcohol, Tobacco, and Firearm Division. And so Rob was writing about the Second Amendment for years. Now he's actually helping to make Second Amendment policy, which is pretty cool. Rob has also his expertise in military law. He authored several essays with Greg Maggs, who's a judge on the Court of Appeals to the Armed Forces, on the Army Clause, the Navy Clause, the Militia Clauses. But today, he'll be talking about the Grand Jury Clause and exceptions to the militia. I forgot. And David will be talking about the Petition Clause, and Nelson will be talking about the Second Amendment. And these are all important topics. So, David, take it away.
Have we been going up there or just sitting
You
here?
just sit here. That's fine.
Okay. All right. Let me get my microphone. All right. So, right to petition. So we all are familiar. We have a First Amendment. We usually hear about freedom of speech, freedom of religion, establishment, sometimes assembly. We kind of neglect the right to petition, which is in there also. So I'm going to...
Is your mic on?
It should be. No.
There it goes. Yeah.
All right, let's start that again. So we all know the First Amendment and the more famous clauses, speech and religion and so forth, but we also have there the right to petition, and while the right to petition has largely been subsumed in the Supreme Court's jurisprudence into the other clauses of the First Amendment, particularly speech and assembly, it does have an independent history and independent significance, and maybe even some modern significance. So I'm just going to basically go through the history and what's going on with it now, and we'll go from there. So the Supreme Court has noted that in some sense the right to petition is the font of all other rights. After all, how do you advocate for rights, how do you defend rights if you can't go to the government and request that your rights be respected? Like again, we don't really talk about the right to petition much. It goes all the way back to the Magna Carta. So the Magna Carta in 1215, which hopefully you're all familiar with, at least vaguely, was the king's response to a petition essentially from his barons. Chapter 61 of the Magna Carta even laid out a formal petition process where nobles could demand redress from the king, and if ignored, the nobles then had the right legally to rebel against the king. King then ignored the right to petition, but at least it was there. Over time, petitioning expanded beyond the noble class. By the 17th century, the Parliament in England declared it the inherent right of every commoner to petition, and the English Bill of Rights in 1689 confirmed that punishing someone for petitioning was illegal. And thereafter, petitioning became sort of a big deal in English politics. It was the ordinary way people interacted with government and shaped legislative agendas, And remember, most people couldn't vote because of property qualifications and so forth in England. So for most people, it was their only way, really, to get involved in politics. The tradition of petitioning carried across the Atlantic. The Massachusetts Body of Liberties in 1641 was the first sort of American constitution or colonial charter, really, to explicitly protect petitioning. By 1774, the First Continental Congress declared that colonists had a right to assemble and to petition the king, and that prosecutions for doing so should be deemed unlawful. The King George III, if you haven't learned this in high school, you at least learned it maybe from Schoolhouse Rock. When the colonies complained, the king said, "I don't care." For those familiar with the Schoolhouse Rock thing. The King George III just ignored colonist petitions, and if you look at the Declaration of Independence, this is one of the grievances that the Declaration lists against the king as to why it was right and proper and legal for the colonies to declare their independence. After independence, nearly all state constitutions guaranteed petition rights, and some of these petitions were about great public issues like slavery, but people would also write petitions about estate disputes, divorces, sentence reductions, and so forth. When the framers gathered in Philadelphia in 1787 to amend the Articles of Confederation, which turned into drafted the Constitution, they didn't actually raise the right to petition, but it was raised by anti-federalists who said, how could you have a constitution that doesn't protect this ancient English right to petition the government? And several state conventions, when they ratified the Constitution, proposed a right to petition amendment. In 1789, James Madison, as member of Congress, proposed an amendment that the people shall not be restrained from applying to the legislature by petition. After revisions, the final language emerged, which is there today. Congress shall make no law, ... abridging the right of the people, ... to petition government for a redress of grievances. And this wasn't just superfluous language. Under the original meaning of the First Amendment, we have freedom of the press, freedom of speech, right to petition. Freedom of press was thought to be public petitioning to government or publicly asking the government for something. Speech was private advice to representatives, and petitions were formal requests to the whole body of government. So that's why we have all those three phrases there. Now, the first actual Congress of the United States received thousands of petitions, and for a long time, Congress actually would formally respond to petitions. After a while, that got tedious, and they only responded to some petitions, usually when a particular member of Congress said, hey, I got this petition from a constituent, we should send a response. The right to petition was considered significant enough that it became a huge controversy that Congress, what Congress should do about petitions from abolitionists. So in 1836, at the behest of Southern members of Congress, Congress actually initially banned responses to petitions on slavery, and then banned people from sending Congress. And you wouldn't go to jail, but they would just ignore you if you sent a petition about slavery, which seems to be a direct violation of the First Amendment. So this was a big controversy. Eventually, in 1844, the gag rule was repealed. The person most responsible for that was John Quincy Adams, but this shows how this was considered a very important part of American liberty. In fact, the South took all sorts of measures to try to stop criticism of slavery. They would stop abolitionist papers from coming into the South and so forth. And another way they tried to stop debate about slavery was through stopping petitions, knowing really that in practice it would be very difficult in a country founded on the principles of the Declaration of Independence to defend slavery. So what about modern developments? Well, the right to petition protects the right to submit a grievance without punishment, but as you are undoubtedly aware, when you write to your congressman, they are not obligated to respond to you. One big change in the United States, which is actually very important, is that in England, the right to petition only related to the right to petition legislatures. In the US, the Supreme Court has held that the right to petition includes the right to petition courts. So you can't deny people access to the courts, at least not to the extent that it violates the right to petition. Over time, of course, petitioning became less important, and instead we have democratic elections where everyone can vote. We have lobbying organizations. We have media. We have websites where you can write petitions, where you can sign petitions now. And again, no one's paying any attention to your petition unless a member formally submits them for consideration. There is, however, one place where petitioning is still very important in our legal system, which is the Administrative Procedure Act. So when administrative agencies are considering new regulations or revising regulations, they are obligated to solicit public comment, and they are not only obligated to, therefore, to accept petitions, they're actually obligated to respond to them if they raise substantive issues. I recently did this. The agency I submitted to did not respond to the points I made, and I'm hoping that someday when the relevant regulations are challenged in court, that is pointed out and they are quashed for that reason. So in any event, the petition right still serves in the administrative agency context as a vestigial living channel of accountability. Also, it does come up in the context of, can you find people guilty, for example, or liable for antitrust violations, for lobbying government. And while the Supreme Court has said, and this is a First Amendment speech right, it actually fits in a lot better with the right to petition. Finally, some open constitutional questions today. Does lobbying by professional lobbyists in particular count as petitioning? And if so, how far can Congress regulate it? Do agencies have not just a statutory duty, but a constitutional duty to consider petitions? And this is not specific to the right to petition, but given how important the right to petition was to structure, to the extent where the court considers moving the locus of protecting rights in the Bill of Rights from due process to privileges or immunities, should it be a privilege or immunity? In fact, it's a particularly good right to be a privilege or immunity of citizenship, because it's really citizens who are thinking have the right to petition their elected representatives. You're not an elected representative of people who can't vote because they're not citizens. So anyway, day after Constitution Day, big celebration of this wonderful book on the Constitution. Let's remember that the right to petition is really still in the Constitution. It has a really important history, very important to the history of American liberty, but it still is there to remind us that we have a right to demand accountability from our government, and this right predates our government itself and helps spark our revolution. Thank you.
So David, let me ask you just one question. I'll go on to Nelson in a moment. A common theme in this book is the Supreme Court sort of subsumes one provision to another. So for example, everything's now free speech, right? The standards are the same. Do you think there's any chance the Supreme Court might actually treat the petition clause as sort of a distinct provision apart from free speech?
I think as the court gets at least more nominally originalist, I say nominally because they haven't really done actually that much yet, and it's not clear how much they can really do. And I think that the at least rhetorical triumph of originalism certainly gives the opportunity for future litigants to say, hey, Supreme Court, since all you, 6 of you claim, or 5 of you maybe, minus Alito, claim to be originalists, you shouldn't treat this particular right to petition issue as simply a matter of speech or assembly. Is actually a separate petition right, and you should also consider, and to the extent that actually might help a litigant's litigation, it could turn out to be significant.
Excellent. All right, next up, I want to turn to Professor Lund. We'll be talking about the Second Amendment. And again, you guys at Scalia don't know how lucky you are, right? You have people like David and Nelson and Rob teaching about the American Constitution. These people are in the mix who are actually teaching the court what they should know. So Nelson, talk about the Second Amendment if you can for a few minutes, please.
Sure. I want to start by...
Do you want to turn your mic on?
Yeah, it's on.
Okay, good. Okay.
Can you hear in the back? So I want to start by thanking Josh Blackman for inviting me to participate in this project, which is a huge, huge undertaking to do the 3rd edition. And I think all of you should purchase a copy and have it available whenever a question comes up about the Constitution. It would be a good place to start. So for the Heritage Guide, I was asked to contribute essays on 3 provisions of the Constitution. As it happens, the Supreme Court turned every one of them into a dead Article 1, Section 8 provides that all duties, imposts, and excises shall be uniform throughout the United States. The purpose of this uniformity clause was to stop Congress from adopting taxes that would disadvantage some states or regions in their commercial relations with the others. Because the goods and activities that can be taxed are distributed unequally through the country, taxing them inevitably has non-uniform effects. In 1983, the Supreme Court held that the clause is satisfied if the subject of the tax is defined in non-geographic terms. This created an enormous safe harbor for congressional evasion because the subject of a discriminatory tax can often be framed without using geographic terminology. The court then went on to say that even taxes using geographic terminology will only be scrutinized for what it called actual geographic discrimination, which the court never defined. A related clause forbids Congress to give preference by any regulation of commerce or revenue to the ports of one state over another. This provision had the same purpose as the uniformity clause, and the Supreme Court has created a similar safe harbor for congressional preferences. Congress may grant incidental preferences through devices such as making improvements, such as dredging, or creating obstructions, like bridges, in one place rather than another. Congress may even impose taxes that only affect the ports of some states, or create tax exemptions that apply to some states but not others. So in both of these cases, the Supreme Court has just put Congress on its honor to comply with their spirit, for whatever that's worth. The third provision that I wrote about is the Second Amendment, which, as you probably know, says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. In 1939, the court issued an ambiguous opinion that the lower courts unanimously interpreted to mean that the Second Amendment only protects the institution of the militia. American citizens, therefore, do not have a right to keep and bear arms, at least in the Constitution. This effectively made the Second Amendment a dead letter, and the Supreme Court allowed this rule to remain in place for decades. The Heller case in 2008, as you probably know, struck down a handgun ban in the District of Columbia. This unprecedented decision brought the Second Amendment back from the dead. In order to understand Heller and its progeny, it's helpful to go back to the founding period. Because of the way the Second Amendment is worded, there's been a debate about whether it protects a private right of individuals to keep and bear arms, or a right that can be exercised only through governmental militia organizations. This question, however, was not even raised until long after the Bill of Rights was adopted. Many people in the founding generation worried that the new federal government might use military force to usurp the role of the state governments and to oppress the people. English history suggested that this risk could be reduced by permitting the government to raise armies consisting of full-time paid troops only when needed to fight foreign adversaries. For other purposes, such as responding to sudden invasions or other emergencies, the government could rely on a militia that consisted of ordinary civilians who supplied their own weapons and received some part-time military training. The Revolutionary War showed that militia forces could not be relied on for national defense. The Constitutional Convention therefore decided that the federal government should have almost unfettered authority to establish peacetime standing armies and to regulate the militia. This massive shift of power from the states to the federal government generated one of the chief objections to the proposed Constitution. Anti-federalists argued that the new Constitution would deprive the states of their principal means of defense against federal usurpation. The Federalists responded that fears of federal oppression were overblown, in part because the American people were armed and would be almost impossible to subdue through military force. Implicit in the debate between Federalists and Anti-Federalists were two shared assumptions. First, both sides agreed that the proposed new Constitution would give the federal government almost total legal authority over the Army and the militia. federal government should not have any authority at all to disarm the citizenry. They disagreed only about whether an armed populace could adequately deter federal oppression. The Second Amendment conceded nothing to the Anti-Federalist desire to sharply limit the military power of the federal government, which would have required substantial changes in the original Constitution. Yet the amendment was easily accepted because of widespread agreement that the federal government should not have the power to infringe the right of the people to keep and bear arms, any more than it should have the power to abridge the freedom of speech or prohibit the free exercise of religion. A lot has changed since 1791. The traditional militia fell into desuetude, and state-based militia organizations were eventually incorporated into the federal military structure. The nation's military establishment has become enormously more powerful than 18th century armies, but it is no longer widely considered a threat to our liberty. In addition, 18th century civilians commonly used the same kind of weapons they would need for their militia duties. That's no longer true. The law has also changed. During the founding era, there were almost no restrictions on the right of American citizens to possess whatever weapons they wanted to have, up to and including cannons. Only the misuse of weapons was forbidden. The reason there was almost no regulation is that there was no political demand for it. We don't know what kind of regulations the founding generation would have considered unconstitutional because the issue almost never came up. In the early 19th century, some states began to adopt limited regulations, primarily bans on carrying concealed weapons. In 1868, the adoption of the 14th Amendment could have radically expanded the scope of the constitutional right to keep and bear arms. There is substantial evidence that the Privileges or Immunities Clause was meant to protect the right to arms from infringement by the states, but the Supreme Court rejected that interpretation in 1876. During the 20th century, both the state and federal governments enacted an increasingly restrictive web of gun control laws. This led to a revived interest in the Second Amendment among the public. The federal courts, including the Supreme Court, as well as the organized bar and the legal academy, continued to assume that the Second Amendment was a dead letter. In the Heller case, a 5-4 majority ruled that the text and history of the Second Amendment showed that it protected the private right of individuals to have arms for their own defense. Because very little Supreme Court precedent existed, Heller offered the court an opportunity to build an originalist jurisprudence from the ground up. The detailed arguments in Justice Scalia's majority opinion largely followed a body of originalist literature created by a small group of practicing lawyers starting in the 1980s. The 4 dissenters disagreed. They endorsed the consensus view that the Second Amendment protects only the right of the states to maintain a well-regulated militia. They also argued, in an opinion by Justice Breyer, that even if the Second Amendment did protect an individual right to have arms for self-defense, it should be interpreted to give legislatures a great deal of deference in dealing with problems like violent crime. 2 years later, in McDonald v. City of Chicago, the court struck down a similar handgun ban at the state level. 4 justices relied on initial precedents under the 14th Amendment's Due Process Clause. Justice Thomas rejected those precedents in favor of reliance on the Privileges or Immunities Clause. But all 5 members of the majority concluded that the 14th Amendment protects the same individual right that is protected from federal infringement by the Second Amendment.
Someone check the Zoom. Yeah, we need more than 10 minutes. No, Nelson, we're gonna fix that.
Yeah, I got it. I'll take care of it.
Okay, thank you.
Okay.
No, you keep going. Yes.
Notwithstanding the lengthy opinions in Heller and McDonald, they technically ruled only that government may not ban the possession of handguns by civilians in their homes. That holding was not based on any evidence about the original meaning of the Second Amendment. It was based instead on the popularity of handguns in the 21st century. Both cases also endorsed a number of modern gun control laws. These included bans on concealed carry, bans on gun possession by felons, bans on disfavored weapons like machine guns, and bans on guns in what the court called sensitive places like schools and government buildings. These endorsements were not explained or justified with any historical evidence. After these decisions, the lower courts upheld almost every gun control law that they reviewed. Most of these cases relied on the endorsements in Heller or on the kind of deference to legislatures advocated by the dissenters in Heller. In 2022, the Bruin decision struck down a New York statute that allowed government officials to make it impossible for civilians to carry a handgun for self-defense. The 6-3 decision relied on the text of the Second Amendment, which unequivocally protects the right to bear arms, and on the absence of any historical tradition forbidding ordinary Americans to carry weapons in public. The court also repudiated the interpretive approach adopted by the lower courts after Heller. From now on, said the court, the government will be required to prove that restrictions on the right to keep and bear arms are consistent with the historical tradition of regulation that existed when the Constitution was adopted. Unfortunately, the Bruin court did not follow its own instructions. It endorsed certain kinds of laws requiring a license to carry a gun without providing evidence of any such licensing tradition. It also endorsed gun-free zones on the basis of a tiny number of supposedly analogous regulations from the 17th and 18th centuries. Last year, the Supreme Court decided United States versus Rahimi, which upheld a federal law that criminalizes the possession of firearms by anyone who is subject to certain domestic violence restraining orders. Chief Justice Roberts' majority opinion did not identify a single historical law that disarmed anyone, including even those who had been convicted of violent crimes. Nevertheless, the court purported to identify a tradition of disarming people whom the government considered dangerous. The majority pointed to laws that forbade people to terrorize the public by going about with dangerous and unusual weapons. But those laws punish people for misusing weapons, not for possessing them. The court also pointed to laws that allowed courts to require an individual to post a surety for a short period of time when there was probable cause to suspect future misbehavior by that individual. Such laws obviously did not stop people from possessing or carrying weapons. The court maintained that these two kinds of laws confirm a principle suggested by what the Chief Justice called common sense, namely that the government may disarm anyone who poses a clear threat of physical violence to another person. Justice Thomas, the author of the Bruin majority opinion, dissented. Under Bruin, when a modern regulation addresses a social problem that existed in 1791, like interpersonal violence, the government must prove that the problem was addressed by an historical regulation with a comparable burden and justification. The historical regulations cited by the majority did not stop anyone from possessing or carrying a weapon. By contrast, the statute at issue in Rahimi completely strips individuals of their Second Amendment rights, even without evidence that they have used or threatened to misuse weapons. Therefore, Justice Thomas concluded the burdens imposed by the regulations are not remotely comparable. In my view, Rahimi effectively adopts the same standard that was used by Justice Breyer in his Heller dissent and by the lower courts during the period between Heller and Bruin. That standard, which Bruin emphatically denounced, is essentially a watered-down version of intermediate scrutiny. It leaves courts with almost unlimited discretion to uphold or invalidate gun control laws, depending on what judges think is sound policy or what they think is politically popular. So much for originalism. Thank you.
Thank you so much. All right, do we have Professor Leider back on?
1 minute.
Okay, let me ask Professor Lund a question. I didn't realize that the 3 essays we gave you had something in common. that the Supreme Court basically nullified them. I didn't actually appreciate that till this moment, so I learned something about the book every day.
I actually didn't appreciate it either until you suggested that I talk about all three.
It's just fascinating. Let me ask a broader question based on your sort of study of the Constitution. Why is it, or how is it the Supreme Court gets stuff so wrong that they can just nullify an entire part of the Constitution for things like guns and things like ports, which are frankly not that relevant to us today? Well, how does this happen?
You want a 1 minute answer to that question? I'll do my best.
Do your best, sir.
I'll do my best. I think that the root of the problem is that our entire legal tradition is in many ways a common law tradition. In the limited sense, that precedent is extremely important in both the common law and statutory interpretation. That's the legal tradition that we began with when the Constitution was adopted. And the framers adopted a written Constitution not in order to get rid of the influence of precedent, which in some other countries, framers of their constitutions did try to do, tried to get rid of the binding influence of precedent. So we have a precedent-based decision, a precedent-based system, and that means anytime there's one mistake, it's very hard to cure it, and if there's a long series of mistakes, it's even harder.
Mm-hmm.
That's why the Second Amendment was kind of so promising in 2008 when the Heller case was decided, because there was very little precedent. And the court had the opportunity to start building an originalist, and they thought they were doing that.
Yeah.
Kind of said they were doing that in the Heller decision, which was written by Justice Scalia. And it's interesting and significant, and of course, in my view, disappointing that has really kind of flamed out so quickly.
Yeah, and I'll note Professor Lund was my professor in 2008 when Heller was decided. He wrote an article, it was in UCLA Law Review, as I recall, that was critical of Heller, and he took a lot of heat from the gun rights community. Saying, well, it's like, Nelson, celebrate. He's still taking it 20 years later. He's like, celebrate, we got this decision. And like Cassandra, he was speaking the truth and no one wanted to listen to him. And we look at what happened in Bruin and Rahimi, I think his warnings were prescient. All right, Rob Light, are you there? Can you hear us, sir?
I'm here, sorry.
Oh, praise the Lord. Okay, the magic of Zoom works. All right, Professor Leiter, let's talk about grand jury exception clause, please.
All right, well, thank you very much for having me. It was an honor to be able to submit the essays that I did with Judge Greg Maggs of the U.S. Court of Appeals for the Armed Forces, who could not join us today, but it was a great writing project with him. It's always a lesson. I had initially written to the Heritage folks saying, your essays on the military clauses could use an overhaul, only to receive an email back from Josh saying, great, why don't you take them? Which is, always the
When you
lesson
volunteer, when you ask for things, you're actually volunteering. You learned that lesson.
Yes, and you asked for that, but I'm happy to volunteer here. This has been a project, as with Professor Lund, I've been working with in the Second Amendment space, but the Second Amendment space crosses the military law space, and so it's an area I've been working, and I was very happy to submit the essay, so thank you very much. Thank you for the opportunity to speak here today.
Of course.
As Professor Blackman mentioned, I am currently serving as Chief Counsel of ATF, and with that comes the mandatory disclaimer that I'm talking only in my personal capacity, not that ATF has much to say about military law, but our acting director is also the Secretary of the Army, so I most definitely don't represent his views. These are just my personal academic views. All right, so the Fifth Amendment says that no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. And so my talk here today will be on these exceptions. These exceptions also relate to the other essays that basically submitted on the organization of the military, the armies and navy.
Oh no.
Well, regulation clauses. But what this clause in the fifth that it's really getting at is under what circumstances can individuals subject to military law? Whether they subject to ordinary civilian law, and can they be subject to the increased burdens, both substantive and decreased procedural protections that military law provides? Now, if you look at the history, historically, military law was a species of martial law. And technically in the dictionary, they're still synonymous, although I think if you asked a military law person today whether they're applying martial law or not, they would bristle at the suggestion because military law has become its own distinct subject area. But that wasn't always so. If you go to if you look back over most of the last 1,000 years, military law was a species of martial law. It was summary justice that was dispensed on the battlefield without any sort of regular protections. Something that Hale said is indulged as law, but it's not really law. Now, there were pockets of established military law. England had courts of chivalry, which went into disuse by the end of the 1400s. Although these courts were not concerned with military discipline. Military discipline was handled very much on an ad hoc basis on the battlefield. Bullshit. It also had greatly established limits. Martial law simply didn't. Thieves sometimes were subject to martial law. And what ended up happening in the 17th century as part of the constitutional reforms in England, the Petition of Right in 1628 the Crown disclaimed most applications of martial law. Martial law was reserved for being in the field during war or for rebels in England. And so martial law would apply if an army soldier were in service in wartime. But even if an army soldier did something wrong in peacetime, they would only be subject to ordinary civilian law. And that framework started to run into problems in the 17th century as England maintained permanent military establishments. So England traditionally did not have a standing army. Troops were raised for specific conflicts. The armies were disbanded after the conflicts. There were a few regular in the Crown's personal service, but and the Navy ship by ship and campaign by campaign. There was not as much central planning as there came to be. And in the 1600s, there was much more centralized control. So the Navy in the late 1640s, early 1650s started getting permanent articles of war. England started maintaining a standing army around 1660, although it's something that it's hard to date the standing army because it was something that, as one author said, became more of it was clear that it had been established after it was done, but in the moment, it wasn't really clear. But starting in the 1660s, you had this institution known as the Army. And from 1660 to 1689, there was no permanent code of military discipline to govern the Army. And so desertion, that was a civil offense. That was a tort. It was not a crime. And England figured out that it was hard to keep a disciplined standing army without some form of military justice system. And as England prepared in the late 1680s to possibly gear up for another military campaign, they decided they needed a form of military justice for the land forces. And so the Mutiny Act was passed. And the Mutiny Act was significant. It only took effect for a year. Standing armies in England is something that was far into the Constitution. England begrudgingly accepted it, but it accepted it through a series of fictions. Standing army would only be authorized for a year a year at a time. So leaving the fiction that it was always a temporary army. And the early mutiny acts were aimed at military discipline. Offenses like desertion and insubordination were punished, but not routine civilian crimes. And this was designed to follow Professor Lund's, as Professor Lund noted, there were a lot of concerns about the standing army, and it was designed to keep the standing army disciplined and in check. And the standing army was not only subject to military law, it was also subject to civilian law. So individuals who were in the military had two sets of legal duties that applied to them. And if you look at the American system, there were early mutiny acts in the colonies, and then when we broke from England, Congress passed an Articles of War to govern the regular forces. Now, some notes. The permanent military law in England only applied to the regular forces. So the Mutiny Act applied to the regular army. The Articles of War applied to the Navy. From 1689 to about the mid-1700s, the militia would still be in martial law, again, only when in active service, and during peacetime was subject to civilian law. And then beginning in the 1700s, Parliament started adding to the Mutiny Act that the militia would be subject to martial law, but only when in actual service during wartime. Now, if you look at the Declaration of Independence, a lot of the grievances have to do with military law and with keeping up with military establishments. So not only did the king keep up standing armies without the consent of our legislatures, the Declaration says, but that he has also protected the soldiers, quote, by a mock trial from punishment for any murders which they should commit on the inhabitants. So getting to the idea that the crown was exempting them from the ordinary privilege, from the ordinary obligations of civilian law. And so when the Articles of Confederation were written, there wasn't some attention paid. Congress got the power to make rules for the government and regulation of land and naval forces, and some power to organize the militia. But as Professor Lund noted, a lot of that power shifted to the national government from the Articles to the Constitution, that there was dissatisfaction about the military establishments. And so the Constitution gives powers to raise and support armies, to provide for a navy, and to make rules for the government and regulation of the land and naval forces, and for the militia to provide for organizing, arming, and disciplining the militia, and interestingly enough, for governing such part of them as may be employed in the service of the United States. Now, these provisions created controversy, particularly the militia provision, that military law would expand into the newly formed United States into civilian life. And one of the concerns was that every male was technically in the militia. And so what was to stop Congress? From applying military law, military age? And the Federalist responded, it's in the Constitution that the federal government could only punish those who were in the actual service of the United States. That didn't allay the anti-federalist concerns. And so out of that came a Fifth Amendment exceptions clause provided for exemptions for the Army and Navy and an exemption for the militia, but only in time of war or public danger. And I would, the other thing I would flag about that is that's what ultimately materialized from the debates. At the time, the scope of the exceptions wasn't perfectly settled. Some of the early proposals said even the Army and Navy would be exempt only in wartime as opposed to at all times, but that ultimately was not adopted. Now, let me finish because I know we're getting low on time, but in terms of modern practice, the understanding of this exceptions clause is not just an exemption from the grand jury provision, but exemption So members of the armed forces all need united. They don't get a pettit jury when they are charged with felonies. They get something different, a court-martial, which in some respects looks like a jury. It has it's a multi-member panel, but it's not. It's a multi-member panel of superiors, not a panel of one's peers. And a number of controversies have erupted under the scope of military law. I'm going to very briefly talk to them, and then so we can get to Q&A. one question is, what does arising under mean? Does it mean that members of the armed forces are exempt from military law, exempt from civilian law entirely, or only for cases that are really of a military nexus? The U.S. Supreme Court originally said members of the military were exempt from civilian trial based on their status. The court in 1969 said no, arising under means more than that. It means that there has to be a military nexus. And then it abandoned that military nexus in the 1980s in a case called Scalia. It's also not clear what parts of the Fifth and Sixth Amendment, if any, apply to the military. A lot of decisions from the military courts and from the U.S. Court of Appeals for the Armed Forces often assume the applicability of certain provisions, such as due process or freedom from cruel and unusual punishment for the Eighth Amendment, but they don't explicitly, a lot of them don't explicitly hold that they are in fact required. There are a lot of questions about marginal cases. Can spouses of deployed soldiers be subject to military trial? And the court said in the 1950s they could not, although there was some early application of military law to a category called camp followers, and also controversies for people who committed crimes when in service but who are now discharged. And the Supreme Court said that those individuals, once they're discharged, can't be subject to military law, even if the crime occurred when they were in service, although some recent scholarship has cast some doubt on the correctness of those decisions. But the biggest problems, and where I'm going to end, are unrelated to personal jurisdiction and one related to subject matter jurisdiction. For subject matter jurisdiction, military law originally was only a few defined military offenses like desertion. Now, if you look at the Uniform Code of Military Justice, it includes a lot of core civilian crimes, murder, rape, robbery, and the like. And so there's been this huge expansion of what military law covers. The second relates to personal jurisdiction. Originally, the boxes were clean. Members of the regular army were exempt from military law at all times. Members of the regular army were exempt from civilian law at all times. They were subject to military law at all times. Members of the regular Navy were subject to military law at all times. The militia only when in actual service. Professional and unprofessional troops are in Navy, the Army, the United States, and components like that. And there are questions whether these part-time troops should be treated as if they were part of the regular Army at the framing, or if they're more like militia. And right now, Congress treats members of the Army Reserve like militia. They're only subject to military law on duty and when in training, but there are other individuals like full-time military retirees who have no continuing military duties, but are nevertheless subject to the UCMJ until they die because they're eligible for retirement pay. And so there, this entry in the Heritage Guide doesn't purport to answer these questions, but the scope of personal and subject matter jurisdiction has been one that has been the subject of great controversy, as well as what the courts theoretically should be doing, whether they should be policing solely personal jurisdiction or whether they have a role to play in subject matter jurisdiction as well. So thank you.
All right. We are over scheduled, so let's go right to Q&A. What questions you have? And Professor Bernstein had an appointment. I'm sorry he had to step out, but I can maybe answer for him. I'll try. What questions you have? Yes, sir.
Professor Lund, you mentioned that there's some lacking historical examples for whether or not the original understanding of regulation is constitutional when it came to early regulations, because nobody thought to regulate that or nobody agreed to regulate that. So what with the text history and tradition principle, what do we look to if people were in such agreement not to challenge that or make a regulation for it?
time I say this, people say, well, what's your alternative? And, the obvious alternative, which I do not endorse, is strict scrutiny. That's the traditional test that's been used by the court in the First Amendment and other areas to try to put real teeth into provisions of the Constitution to protect individual liberties. The reason I don't endorse that is that it has become so debased
Yeah.
by the Supreme Court in the way that it's used it. Even if you could try to go back to something like that, you would have to get rid of intermediate scrutiny completely. You would have to say it's only something like rational basis or something like strict scrutiny. Because of the debased state of the law of tiers of scrutiny, that's going to turn out to be not what we believe in. The alternative, it seems to me, is a kind of means-end analysis that starts from the purpose of the Second Amendment. And the purpose of the Second Amendment, which was correctly described in Justice Scalia's opinion, is to protect the inherent or natural right of self-defense. That's the purpose. And so how do you judge what governmental provisions that are perfectly legitimate in their goals to protect all of us from violence and so on? How do you decide which ones are constitutional, which ones aren't? I don't think there's an easy answer to that. I think I can give you an example of something that would be a pretty easy case under that approach. And it's an example that Justice Alito offered at the oral argument in Bruin. He said, well, and I'm obviously paraphrasing, why don't we start with the purpose, which he agreed with me about what the purpose is, and he said, leaving aside the military aspect of the Second Amendment, leaving that aside, ask whether that purpose is being served by a given regulation. And he said, so for example, and there's been a lot of discussion at the oral argument in Bruin about sensitive places, schools, government buildings, and things like that. He said, well, what if we said something like this? If a building is protected by the government through, magnetometers being employed before you can get in, and government officials there to protect you, well, then you're safer there than you would be out on the street, even if you're disarmed, than you would be out on the street, even if you're armed. And so that's a fair trade-off. You're getting more safety for everybody, including you, when you enter a building like that. And so that would be compliant with the Second Amendment. And Justice Alito, of course, said, now this isn't going to solve every question. This is an easy case, but he said that would be a place to begin. And I think the important thing about Alito's question there, or argument, is he was asking the right question. That doesn't mean it's going to always be easy to come up with the right answer, but he was asking the right question, and that's the first step towards developing a jurisprudence that makes some sense and is compliant with the Constitution, in my opinion.
All right, over there.
Yeah, Professor Glenn. So in First Amendment free speech, we have the private.
Speak up, I'm sorry.
Sure. In First Amendment free speech realm, we have prior restraint in protecting speech from overly discretionary permit systems. Do you think there's merit to try to apply a similar kind of doctrine to the Second Amendment with concealed carry permits or open carry permits, or does Bruin minority do that?
Yeah, I guess there was a time when I thought that, and first let me say, I think there's some really important analogies between the First Amendment and the Second Amendment, primarily in the sense that both provisions are worded extremely broadly, so broadly that if you took them literally, they just wouldn't make any sense. One limited exception there might be with respect to the federal government. You can imagine the federal government completely
All right. I think we are aware of a schedule. Thank you all so much. Thank you, Professor Lund. Thank you, Rob Leider. Have a wonderful day, everyone.